Your Honor, the defense has argued that this case is purely about insurance coverage and should be decided through arbitration. But this case goes far beyond a simple coverage question. It resolved around the false promises made by Moscow agent Molly. Woman client Justin and Paige Sherman sought insurance to protect their home from potential subprime failure. They relied on Miss Molly assurance. She specifically told them they did not need a particular rider for subprime failure related issues because they were already covered. This assurance led my client to purchase the policy. Now, when faced with a denial claim for substantial damage, they find themselves with no coverage and a serious breach of trust. This is not about interpreting policy language. It is about a deceptive conduct that led to purchase of inadequate insurance. The defendants claim that the arbitration clause within the policy apply broadly and should bar my clients from bringing their case to court. However, the language of the arbitration clause is clear. It states that all dispute between the insurer and the insured must go through arbitration, limited to determining whether or to what extent a claim is covered by the policy as written. This is key. The clause was designed to handle disagreement over what the policy covered, not to address claims of fraud or misrepresentation. My clients are not merely disputing what is covered, they are arguing what that they were led to believe through specific and false assurances that their policy provide coverage that it did not. This is a matter of fraud, and fraud is not a simple coverage dispute. It is a thought that requires careful examination of the fact beyond the limited scope of an attributed authority. The defendant asserts that my clients knowingly agree to the term of the policy, including the arbitration clause, and therefore must be bound by it. But this overlooks the reality of how insurance contracts are often presented. Insurance policies are class example of adhesion contract offered on a take it or leave it basis, with little room for negotiation. The terms had no meaningful way to alter or challenge the arbitration provision. They trusted Moscow and relied on the expertise and guidance of Miss Molly Curley, who acted as a company representative. When a company issued a superior bargaining power to impose restrictive terms, then rely on those terms on block legitimate claim of fraud, the court have every reason to find such clauses unconscionable and unenforceable. The defense goes on to argue that arbitration is a cost-saving measure that benefits both parties, avoiding a lengthy litigation. While this may hold true in routine dispute over policy coverage, it does not serve justice in cases like this one, where the central issue is deceptive conduct. My client did not enter into arbitration willingly. They were forced into it by a contract that was misrepresented from the start. Arbitration, in this case, served only to shield Moscow from accountability for its agent's false assurance. It cannot and should not be used to deny my client their day in court when the matter at hand is a serious claim of fraud and misrepresentation. Opposing claims that my client knowingly denied the sub-pump rider, but the reality is that their decision was based entirely on the information provided by Molly. She told them the rider was not necessary and that they were already covered. My clients trusted her words because she was the expert and they relied on her guidance To now claims that the attorneys made an informed decision, ignore the fact that their understanding of the policy was shaped by misinformation. This is not a simple matter of coverage choices, it's about fundamental breach of trust. Your Honor, we must also address the defendant's position that arbitration is a common practice and therefore fair. While arbitration clauses are indeed common in many contracts, their enforcement must be balanced against the principle of justice and fairness. When a company uses an arbitration clause to bar legitimate claims of fraud, it crosses the line onto unfairness territory. My client were misled into purchasing an inadequate coverage based on false misrepresentations. To allow the arbitration clause to stand in the way of their pursuit of justice will be to permit companies to mislead customers to impulsively, knowing their actions can be shut from their serenities. In conclusion, this case is not about policy terms alone. It's about holding a company accountable for the words and action for its representative. Fraud and misrepresentation cannot be treated as a routine coverage issue. The arbitration clause, in this case, is being misused to protect Masco from facing the consequences of its agent conduct. We respectively ask this court to find a clause that does not apply to a claim of fraud, or alternatively, that it is unconscionable and unenforceable under this circumstance. Your Honor, my clients deserve a day in court. They deserve the chance to seek justice for the harm caused by false promises. We ask that you grant them that opportunity. Thank you.